And it looks like I'm live. So, good morning. Sorry, I'm a little bit late. I'm what's known as not a morning person. So, the judge is already getting set. So, I'm just going to get started and let all thousands of you trickle in. So, let's do this. Looks like Mr. Brooks is in his cell still. So, let's see how long it takes until we get finished with the pre-trial stuff and get into opening statements. He's not capable of stopping talking. There's no way he stays in the courtroom. She's read the case law out loud multiple times. Dressed? I think he wants to prejudice the jury by wearing orange. Yep. He thinks he can appeal his choice to wear orange. And the jury's not supposed to be watching news coverage of this, saying respectfully doesn't make it respectful. Mr. Brooks would argue about the sky being blue. It was a non answer. That would be a repetitive motion. Use the shocks on his ankle. Get P. Barnes in there. You also have the right to waive that right through your behavior. Now that it's a break, since I jumped straight in, I don't know what's going to happen today. Scheduling wise, the plan is to do the opening statements this morning. The news I've read has been a little contradictory. Some have said they're going to continue pre-trial stuff and then get to it. Others have said opening statements at 8:30 Central Wisconsin time, which is 7:30 here in Utah, which is too early. So we'll see what time we get to this. And I think that now would also be a good time to discuss what exactly happens at trial. And there are hints in the words used. And I think Mr. Brooks is going to struggle with this because this morning it's opening statements. A month from now, it's going to be closing arguments. Notice statements today, arguments at the end. Mr. Brooks, I fear, is going to do nothing but argue this morning. And while it is generally viewed as poor form to object during opening statements, I have a feeling the prosecution is going to be doing a lot of objecting because he's going to argue. And he's going to argue things that are not going to come in evidence. And that's something you have to be aware of in giving opening statements because if you promise the jury you're going to show them something during the testimony phase, you have to show it to them. They'll remember and they'll hold it against you if you don't. And therefore you have to be aware of all of the pretrial motions, what has been excluded, what has been allowed, and the feed has just done something funny, so we'll see what happens and see if they've opened a new feed. They snuck one in on me yesterday. Unfortunately, it's too early for my brain to be turned on fully. My internet has decided it likes being slow this morning. And this is probably a good opportunity while we wait to also take a look at the Wisconsin statutes. The obviously he he's facing 70 some charges. I haven't actually looked at the indictment. 6 of the charges are homicide charges. And I'm he's charged with first degree intentional homicide. I'm trying to avoid the M word this early in the stream for YouTube's sake. But I'm sure he was charged with what are called the lesser included crimes. So with that, you're you'd be charged with the first degree or second degree intentional homicide, but you'd also be charged with manslaughter. And what happens is if you're found guilty of one of the intentional crimes, one of the higher crimes, the lesser included charge merges into the higher crime. And so you're not technically found guilty of it or sentenced for it. But you can be found not guilty of the higher crime, and then they move down the list and look at the lesser included. And this is important because this is a trial where they know who did it. They are absolutely 100% sure that Mr. Brooks ran his truck through the parade crowd. What they are going to have to prove is intent. Because if he intended to run his truck through the crowd and to hit people, that is what it's called intent. He voluntarily, he knowingly ran through the crowd. But it would be manslaughter if he recklessly. Well, let, let's look at the statute. In Wisconsin, it's Wisconsin Revised Statutes 940.06, second degree reckless homicide. And it's a very simple statute. Whoever recklessly causes the death of another human being is guilty of a Class D felony. Now, the standard for reckless is in criminal law, this is the element we call mens rea. There's the actus reus, which is the physical action of the crime, and then mens rea is the mental part, the intent. And you have the per se strict liability crimes where in essence there is no mens rea. This would be like a speeding ticket. Whether you meant to speed or not, whether it was negligent or not, if you're speeding, you're speeding. The next level up is negligence, and then reckless, and then you get into actual intent. So this reckless is a very low standard. because if Mr. Brooks didn't mean to hit people, but drove through the crowd knowing the risk of hitting people, that's reckless. At the very least. But it could even be if he had a medical condition where he knew he might black out or have a seizure or something, and approached the crowd in his car and did black out and drive into the crowd. That could also be reckless. He didn't have any intent whatsoever to drive into the crowd, but he was reckless simply by driving near a crowd having that condition. So, I think at the very least, this is going to be easy for the prosecution to prove this charge. But then there's also 940.10, homicide by negligent operation of vehicle. And this is whoever causes the death of another human being by the negligent operation or handling of a vehicle is guilty of a Class G felony. So remember, I said negligence is the lowest true level of mens rea. So, at the very, very, very least, for these 6 deaths, he'd be guilty of 6 Class G felonies. But let's s- scroll up. Second degree intentional homicide. Whoever causes the death of another human being with intent to kill that person is guilty of a Class B felony. And it looks like we might be back in the courtroom. I'll keep looking at this until they start talking. Oh, it looks like Judge Darrow is back on the bench. So let's and Mr. Brooks is not at the council table. It hasn't been said. I imagine the jury is not present yet. Hopefully, this is the opening statements instead of more housekeeping. I wonder if he did get that mint on his pillow last night. As I mentioned yesterday, I really like Judge Doro. I really like Attorney Oper, the woman on the far left of the council table. And from what I've seen, the other two attorneys are very good too. I wonder if Mr. Brooks is in changing into his suit or if he's been removed to a cell. And if you notice, they have the black drapes around the council table. They mentioned that before this recess. It's because Mr. Brooks has his ankle shackled since he is in custody. And so that he's not prejudiced by the jur or so the jury is not prejudiced by seeing him shackled. They have the drapes around the table, but they also draped the council table so that they don't wonder why one has a drape and the other doesn't. You can see the drape now. Uh-oh. Apparently, orange isn't his color. This is going to be a mess. All right, my internet needs to wake up too. All right, come on, I'm specifically not using Wi-Fi, so the internet will work better. Like I said yesterday, I need to take bets on how long he lasts. Ah, good morning. It's going to be a long day, I have a feeling, so I definitely look forward to chatting with you throughout the day. Hopefully, my internet stops lagging. All right, come on. No Zoom because Court TV is using much better equipment. Nope, you haven't. Except for me being a little late. Did I seriously not share the sound? Good morning. I guess hello in the middle of the night. Alright. Well, that's embarrassing. Let me see. I can't remember how I got this going yesterday. My internet's being annoying. I did it just fine yesterday, I swear. This is why I needed people here to tell me half an hour ago. Luckily, she's still just going through housekeeping. Mm, I did this a little different yesterday. Let me see. Yesterday, I didn't have my second monitor working, so I did. Let me see. I shared the tab. Whereas today, I shared the video file or shared the second stream. So let me. Okay, this is frustrating me. Present slides. No. Okay, share Chrome tab and share that one. Make that full.
I can see his hands moving. He has turned his back. I can tell that he can hear me because he shakes his head
All right,
no.
can you hear it now?
At a point in time where it's clear he's disagreeing with something that I've said, I believe he can adequately hear, and that his statement earlier in
All
the
right,
proceedings
good.
that he's hard of hearing is simply another tactic of his to disrupt,
That's just
to delay,
embarrassing.
to create chaos.
I'll
I
have
will
to
further
figure out
advise
how to cut that
Mr.
first half
Brooks
hour out.
that his continued behavior, whether it be appearing in court in jail attire, whether it be causing disruptions in front of the jury, that he does all of those
The discussion
things
so
at
far
his
has mostly
peril.
been
But I will, of course, take
whether he
appropriate
appears in
steps
the
to
orange
limit what the
jumpsuit
jury
or
can
in
hear if
a suit and
appropriate.
tie. He apparently doesn't want to wear either, as you can see.
All right, I've received a note, we need to reset the Polycom system, so I'm not sure what that means. I'll find out, and if appropriate, make a record as to why and whether that impacted anything that
And
was
it looks
happening
like
in
my
the other
internet's
room.
finally working a
But
little
at this
better too.
point, well, I'm not going to get off the bench. We're going to take a short recess for that resetting to take place.
I would request an opportunity to be heard then, Your Honor, when we go back on the record, please.
Absolutely.
So what, Starlight, what time did you say it is in New Zealand? Did you say it's 3:30 right now? As I mentioned before you got in here, I'm not a morning person. I'm pretty much what's known. I'm pretty much nocturnal, so you can probably see it in my eyes right now that I'm exhausted. When I commented to you yesterday, well, I guess it was still, well, yesterday for you. It was just past midnight, and my brain just wasn't even thinking about sleeping yet. So I'm typically not in the live chats of the other creators I watch, mostly because I watch the restream at about, well, until about 3 a.m. So on the off chance that I do catch a live, I actually did catch Law Talk with Mike yesterday. That was a prime example of why I never want to do family law. That was just an absolute mess. So I actually was in the chat for that. The same is true of me usually. I When I watch YouTube, I tend to do it on my TV on a different account than this one, on my personal account. And then if I get in the chat, I'll open it on my phone on this account to join in the chat. so so if I do catch it live, they get 2 views from me. He can find some well, it's to the point where he doesn't have to find it. His audience finds it for him, but there's definitely weird stuff out there. Zoom Court really has. I think it's both exposed the crazy in people, but it has also brought out the crazy in people. If you're facing immediate arrest for contempt, which doesn't happen all that often, but it happens a lot more to people physically in court than if they're appearing over their phone. And I think people have just forgotten how to act, which is unfortunate. Of course, as Law Talk with Mike says frequently, if we as attorneys acted that way, we would be arrested very quickly. The behavior Mr. Brooks has shown this morning, that while it was unfortunately muted while I was having my issues, had him removed from the courtroom, it would have me arrested. And I have a feeling he's going to spend the vast majority of this trial in the adjacent courtroom. That I hate to say, I don't think he can behave so much as he's not willing to behave. I did my master's degree in finance at Durham University in Northeast England. And that's actually where I first got the idea that I might go into law. And I explored becoming a solicitor over in England, um, because it's a very different system. Uh, and they actually pay you to go to law school if if because a firm will hire you and then send you to 2 years of law school if your undergrad wasn't in law to begin with, and that would have saved me a lot of money. And I also I realize New Zealand is not Australia, but there's a Netflix had the Australian legal comedy drama Rake, which that's pretty much other than sovereign citizen YouTube videos. That's my fictionalized exposure to the Australian and court system, which I that's a really good show, basically, is what I'm trying to say. I'm tired, so my brain's not functioning. And obviously, I'm not a doctor. I'm not a medical professional. The Depp Heard trial, we heard all about the Goldwater rule from Dr. Doofenshmirtz, or I can't remember his real name. But since I'm not a psychiatrist, I'm not beholden to the Goldwater rule because that's a rule of professional ethics, and I'm not a professional. So I will opine on his mental health. He is crazy like a fox. He he knows what he's doing. He knows what his behavior is. But last yeah, it was last week during the Ferretta 2-day Ferretta hearings where Judge Darrell was deciding whether or not he could represent himself. The judge referred to his psychiatric evaluation from I think it was from his competency to stand trial phase, but she was using it in the phase competency to represent himself. And she did refer to him as being diagnosed with a personality disorder. I don't know what personality disorder it was. It it very well could be oppositional defiance disorder from what we've seen. But I would I wouldn't be out of line saying, yes, he is crazy. He does have mental health issues, but it's important to note that does not mean he is incompetent to stand trial. It does not mean he is not competent to represent himself. He is both of those things. Well, he is competent at both of those things. So it's a very, very, very high bar to be declared incompetent to stand trial.
System has been reset. The information
You
I
don't need a
received
pass.
was that all of a
It's
sudden
an absolute
the audio
right.
was only going through 2 speakers and not
But
all of them. A simple reboot of the Polycom system
That-
over there took care
they
of
have
that,
to make
and
sure
I've
you're
confirmed that
able
it's working
to
properly.
represent yourself.
Before I turn to you, Attorney Opper,
I
because
don't
I'm
know.
not sure if Mr. Brooks heard this or not, at the very end, before I removed
I do
him,
know one of the
I wanted
charges
to
is
make
for trying to
sure,
run down his wife.
that the record is very clear. I will
before
note a continuing objection to the issues he raises regarding his name and other things.
There's a lot of malingering.
There are findings
So
that substantiate
it
that.
does need to be
It would
a high
my
bar.
position, it's not needed for him to do that every single day because I've noted a continuing objection. With that, you wanted to make an additional record?
Yes, Your Honor, it's probably appropriate at this stage. I did want to address a topic that's maybe not been raised in the courtroom, but has been raised in the public, and it seems to kind of go hand in hand with the events of this morning, and that is the mental competency of Mr. Darrell Brooks to proceed to trial. The court is well aware that the district attorney has an obligation
I
and a
use
duty to raise
imprecise language
any
all the time.
concerns as to the competency of any defendant to proceed to trial. Any counsel representing Mr. Brooks would have that same obligation, and the court itself, if it had a concern as to the competency of any defendant
Speak of the
to
devil.
proceed, can request an evaluation that's pursuant to 971.14. of the Wisconsin statutes. At no time has anyone involved in this case had a competency concern. And I say that based on the fact that Mr. Brooks has made multiple court appearances, most of them before Your Honor, but at least initially he appeared before two court commissioners. He's had counsel representing him
Darn autocorrect.
up until last week on this case. And you've made a record with Attorney Perry previously as to Mr. Brooks' ability to understand what's going on and his ability to participate in his own defense. You made a thorough record last week when you went through his
He'll never comprehend what's
waiver
going on
of
if he's
right to an
facing
attorney
backwards,
and
shouting
his
all the time.
absolute desire that he expressed multiple times to represent himself. I would also add to
Uh-oh, I thought I was over my internet issues. Come on.
he is coherent, he is intelligent, he knows the issues in the courtroom, he discusses what happened in court.
I think
day
that
with
one wasn't
these,
my internet.
individuals he's speaking to.
It was the
I am
law and crime or
thoroughly
YouTube
convinced, Your
internet.
Honor, that Mr. Brooks is 100% competent to proceed to trial, that his mental capacity is not reduced in any fashion. Anybody that thinks otherwise has no involvement with this case. I would reference the court to today's filing, which Mr. Brooks provided. It is extremely well written. His handwriting is immaculate. It's perfect. The punctuation, the grammar is 100% accurate. He
If handwriting were the
drafted this himself in his
bar,
jail cell last night.
I could never be a
presume.
lawyer.
Maybe it was this morning. He has continued with the same objections that he has been making repeatedly in this case. So he clearly understands the issues. He understands the defense that he wants to pursue. He undertook the effort to have this form notarized by a jail employee so that it is a signed and sworn affidavit. Absolutely no concerns on the part of the state of Wisconsin that Mr. Brooks has any deficiency in his competency. We are 100% convinced that these actions of Mr. Brooks are deliberate and intentional, and they have escalated, and the court has seen this since August 25th or so, as the motions were decided by the court.
I'm laughing because notarizing everything is a common sovereign citizen thing.
More and more difficult in the courtroom. It started out less aggressive with him sleeping and asking to be able to leave the courtroom. Then we had a toothache. Then we had
all delay
situation
tactics.
Where he didn't want to come to court, was refusing to come to court. The record will be clear, Your Honor, that each time, and the Sheriff's Department has done an absolutely fantastic job dealing with Mr. Brooks fairly, professionally, respectfully at all times. We concur 100% with the record you just made as to what happened after the recess at about 8:42 this morning as to Mr. Brooks' conduct. These are deliberate actions on his part as we get closer and closer and closer to actually presenting this case to a jury, that he is attempting to derail these proceedings and avoid the inevitable. And I want to make that record. I tell this court as an officer of the court, we have zero concerns as to the mental competency of Darrell Brooks to proceed. And we have had many, many dealings with him on the record and off the record that I base that on. I also wanted to add one other comment as to the court's record as to the need to proceed with this trial.
Bad behavior.
We concur 100%. We would also note
And
it's not just a matter of resources.
He is on video
It's
screen.
the need to proceed to justice. It's
when the
need
jury
to get
comes in, they
justice for the
can
crime
see him.
victims who have patiently attended
So
every one of these hearings. They have
This
a
technically
constitutional
wouldn't
right
be
to trial. They have a
a trial in
constitutional right
absentia.
to a speedy disposition of this case. And that doesn't mean hasty. That doesn't mean reckless. It means efficient administration of justice. And this court has provided that to the crime victims. And we think that's another reason that Mr. Brooks' antics, which is all they are, clearly speak for themselves. This is not his inability to understand what's going on by any stretch.
And the
Thank
judge
you,
did
Attorney Ackerman. I
cover
do appreciate you
the
raising
legal
that with
standard
the
yesterday
court,
and the day before.
because I share your observations that you've just noted on the record. I would adopt them fully as if they were my own and make them part of the findings that I've already made on the record. Obviously,
don't want
I
it
personally
overturned on
haven't listened
appeal.
to the jail
They're
phone
making a
calls that
full
you
record.
reference, but I do take your statements as an officer of the court. I look forward to further reviewing them, if need be, changing any conclusions that I've reached here today, and I would require you to file that exhibit so that that can be part of the record as well. I would also add to what you have just stated. This court has read through not one, not two, not three, but 4 evaluations related to the special plea that was withdrawn. And those are very recent evaluations where the
I believe that's his
examiners
insanity plea.
met face to face in the jail or in a appropriate visitation room with Mr. Brooks, either in July or August of this year. And every single one of those individuals did a mental status exam that's noted in their reports. Frankly, the behavior that we're starting to see here is no different than some of the behavior that was noted by those examiners as well. This behavior is frankly more in line with someone who's defiant, deliberate, and in line with the conclusions related to whether he suffers from a mental disease or defect that would qualify for a special plea. I've not gone into much detail, and I won't. Those documents are part of the record, but it's very clear to this court that everything that he has done, as outlined by the state and as made evident on the record of these proceedings, that it is the sole intent of Mr. Brooks to make a mockery of this process. And I've stated, and I'll state it again, I'm not going to tolerate it, but there is.
He's trying to
I
make a
believe this
mockery
trial
and
needs
delay.
to continue, should continue, not only for Mr. Brooks as the accused, who also has the right to a speedy disposition. He hasn't exercised it. The victims have a right to a speedy disposition. And it's important for the justice system to go forward with this proceeding. We are at the stage where we are at with Mr. Brooks muted in another courtroom.
She's
because
brilliant.
of his defiant actions.
She's exactly what a
No one
judge
else.
should be.
And I appreciate everyone's patience as the court goes through these things. Frankly, gives Mr. Brooks time after time after time to conform his conduct to the clear expectations, but he just simply flat out refuses to do so. So what I'd like to do is finish with the approval of the jury instructions, the preliminary jury instructions. I will make a record that Mr. Brooks did not file anything in writing regarding a proposed jury instruction, as he was advised to do yesterday.
He doesn't consent to the jury
If he
receiving
wanted me to
instructions.
consider something. I believe we had a very clear discussion on the record about that. He was given a full copy of the draft preliminary jury instructions. He was part of that conference that we held yesterday. There was even a discussion regarding where he could find jury instructions with the legal materials that he has access to in the jail. Although he didn't take it to his cell yesterday, he has had the selected statutes that I referenced yesterday that also have the rules of evidence. And so I wanted to make that record. I don't have anything from him this morning regarding any additional jury instructions Has the state had an opportunity to now review the preliminary jury instructions with all the changes that were made yesterday?
We have,
Any objection to those?
no.
All right,
Of course not. They wrote them.
Mr. Brooks, I'm going to unmute and ask you if you have any objection to the jury instructions that were provided to you yesterday. I'm specifically looking for a yes or no answer, and I'll address further if need be based
Nah,
upon that.
I
yes
just
or
want
no.
to see him stay
The
in the
microphone is
courtroom, but
unmuted.
I want him gagged. Maybe a hood over his head, too.
Actually, we'll need to turn him up. It's not very loud on our end. Mr. Brooks, did you say one more time?
Sovereign citizens are kids.
Yeah, but you know what? Your volume's a little low, so
My
we're gonna
7-year-old
have
niece
them adjusted over there and in
is
here. So
far
just a
more
second.
mature than him. But I think I figured him out.
Where is the microphone?
His shirt's off because he's
Looks
going
like it's in front
for
of the monitor.
not guilty by reason of thirst trap. He thinks if the jury finds him sexy, they have to acquit.
Mr. Brooks? Try again.
Am I on the record?
You are on
Me
the
too.
record. Ooh, that's loud now. We'll turn ours down. Mr. Brooks, yes or no question, do you have any objection to the preliminary jury instructions that were provided to you yesterday?
Hey, I got participation trophies.
Go ahead, answer, please.
And part of the reason I don't like capital punishment is I think it's
All
more
right, your
punishment
objection is noted for the record.
spending decades in
and,
jail.
I'm just putting the
in
mute
prison.
back on.
Capital
He
punishment is the
provided that
easy way
objection
out.
without any legal basis. I muted him just so I could ask this question. I'll be right with you, Captain. Mr. Brooks, do you have a legal basis to object to those preliminary jury instructions? I'm unmuting you.
We've invented a new legal
Hold on,
standard
the
here.
volume is not being appropriate at the moment.
Of course, there's the hot felon from several years ago
Their name's,
who got a modeling contract off of his
try
mugshot,
it again, sir.
which I don't
I
understand, but
apologize for the technical issue. All right, the technical, we're gonna have to figure that out. It's not appropriately working. I do appreciate that he was able to hear me because he leaned in to answer. So I just want to make that record. I'm gonna go take a recess. I'll
It
just
does.
while we're doing that, just so I can
and
figure out what the audio issue
sometimes
is, and then we'll go from there.
not seeking vengeance is hard. There are people that I look at what they've done, and it's hard not to say, I want the death penalty for this person. It's hard. But I think it makes me a better person. And I'm always striving for improvement. But it makes me a better person to strive to not forgive, but to accept if that makes sense. So unfortunately, that means I could never serve on a capital jury because that's one of the disqualifying answers is they do ask, can you impose the death penalty? And if you answer no, you can't serve on that jury. Which that's pretty much the only form of discrimination that is allowed in jury selection, which I say discrimination. It's not a protected class. It in everyday life, discriminating against people for not believing in the death penalty, not supporting the death penalty, isn't unlawful discrimination. But you could make the argument that in disqualifying people from the jury for this reason, that it is because it it very well could be disqualifying people based on their religion. A Quaker could never serve on a death penalty trial because of their religious convictions. And religion is one of the areas where you can't discriminate in selecting a jury. You can't discriminate based on race. And to me, this is kind of funny. The Supreme Court, in deciding the case that you can't discriminate based on race in jury selection, they didn't find it it wasn't the defendant's rights that were being violated. It was the potential juror for being eliminated based on their race, which isn't the intuitive way to me to decide that case. But even though it's not intuitive, I do agree with it because while it's called jury duty for a reason, you do part of your responsibility as a citizen is to serve on juries. But it is also a right to serve on juries, not necessarily to be picked on for the jury, not um I came close. Well, I had to show up. The most criminal trials, well, criminal cases don't go to trial. And lots of times it is a game of chicken. And the defendant will insist, I'm going to trial, I'm going to trial, I'm going to trial. And then they show up the morning of trial and they're in front of the judge. The jury is in the jury room. Well, the veneer is what it's called. The potential jury. And you're getting ready for jury selection and the defendant has his oh crap moment and says, "Oh, I'm about to go to trial and they're going to find me guilty. I better take that plea deal at the very last moment." So the judge sat us in the courtroom next door and said, "Hang on, we're the lawyers are discussing things." And then she came in and said and described exactly what happened, that the defendant took a plea deal, that our presence helped him take that plea deal and dismissed us. So that's the closest I came to serving on a jury, which at the time I didn't want to. I actually would be interested to serve on a jury now, but I doubt it'll ever happen, even if I'm called I'm sure I'm the first one dismissed. Generally, lawyers do serve on juries sometimes, but it's pretty rare. I did actually have a law school classmate who, during law school, served on a jury. Her dad was a career prosecutor for the U.S. Attorney's Office and had just been appointed as a state court judge. She was top of her class the year behind me in law school, but she was in my evidence class when she was selected for the jury. So the judge said, "All right, you're excused from class for the week, but next week you have to come in and tell us what you learned." And which she did. And the judge and the prosecutor, and I think even the defense attorney, knowing that she was a law school, after the trial, they took her back and they explained everything that happened while she was in the jury room that that jurors aren't allowed to see. So, as a lawyer, I think that would just be fascinating to see that. And now that I've done my soliloquy, I don't know I don't know what they could change, frankly. It's a very human thing, jury selection. And the best they can do is get a random sample of the defendant's peers and try to remove as much bias as they can. And in this case, they have gone over and above in attempting to do that. They started the jury selection process months ago. And they actually this is actually something that could change because it's not standard practice. But they sent out a pre-questionnaire to a very large panel of prospective jurors to have them return just so that they could weed out people who knew victims and not drag them in. But they still brought in a panel of 300 potential jurors, and they were going to go through them 100 per day until they had a jury seated. So at least 100 never came in because jury selection only went 2 days. But the process that they have done in this case has actually been excellent. And back to capital punishment, it if we're going to have it, it should be rare. It it would need to be reserved for the worst of the worst. I just last week watched the Jeffrey Dahmer case. Speaking of killers in Wisconsin, um, and the that Netflix show, the Dahmer can't remember exactly what it's called. It was pretty good. I enjoyed it, and that to me, if you're going to have capital punishment, that's sort of the level where you might convince me. But in lots of states, it's viewed as sort of the default, which I don't like. Luckily, jurors understand generally it is a very high bar, even in cases where it's charged as a capital case. It is still very rare for a jury, I can't speak, to impose capital punishment. Here in Utah, we do have capital punishment. It has been 10 years since the last execution, I think, roughly. And Utah is kind of unique because we still technically have firing squads. Which this is another strange legal precedent, I think. Um, but I fully understand it. Utah has technically removed the firing squad from the allowable execution methods. But for anyone who received the death penalty before it was removed, it was grandfathered in, because if they said, well, you could have been executed by firing squad before, but now you can't, that's grounds for appeal. And they don't want that. And as fun as strange as it sounds, those convicts on death row have the right to be executed by firing squad. And I think it wasn't the last execution in Utah, but the one before that, which is going back 15 some years, was a firing squad. And I think a big part of the reason why that was chosen was the the condemned wanted to embarrass the state of Utah. But even though it is barbaric, it is quicker than lethal injection. So in some ways, uh, there's been talk about bringing it back. Gotham City probably would have been much more safe if that had been the standard, because the Joker would have qualified for that one. I think. Once again, I'm not a psychiatrist, but I don't think the Goldwater rule applies to diagnosing the Joker. Um, Lethal injection should be pain-free, you'd hope. I've never experienced it, so I can't say for sure. But it it has gone wrong. There Speaking of the Dahmer show that I just watched on Netflix, there in the final episode where they covered Dahmer being killed by a fellow
Here to have
inmate,
our technical issue
they covered John
resolved.
Wayne Gacy.
That issue
And
solely concerned the audio.
the first
from the
attempt
microphones in
failed,
front of Mr. Brooks.
and they had to
and the two room
re-inject
systems
him
cooperating.
20 minutes
And
later.
we were having difficulty in this
that's not
courtroom
uncommon.
hearing Mr. Brooks. I believe that issue has now been resolved.
That was a
Then I
technical
needed to take the
difficulty
break
recess.
for the audio issue. I also was advised by the captain that Mr. Brooks was requesting medical attention and reporting a small cut to a finger as a result of
Call off the trial.
when he
He's got a
was
cut on his
removed from this
finger.
courtroom and taken to the other courtroom. I was further advised that there are no signs of blood, and that when asked, he refused to show his hands. At this time,
He objects.
I'm not going to pause the proceedings further for him to be seen by jail medical, but at an appropriate break, that will be done.
Oh, man.
And I also want to make a record that Mr. Brooks has put his shirt back on. He continues to sit with his back to the camera. Mr. Brooks, I want you to be advised that I believe it's important that you face the camera so that you are
I wonder if
facing
he
the
ever
court.
did
You can see
consent to the
and hear.
rapid
It's
plague
my understanding
test.
you were not willing to cooperate with being shackled, and for the moment, you are not. But at this point, given your conduct from before, I'm going to require, after we take the next break, that the sheriff's department put you in the chair face forward and with shackles on your ankle, as you are in custody, and that is appropriate. Now, I want to
Not
turn
gonna
back
like
to
that.
the issue with the jury instructions, Mr. Brooks. You indicated you had an objection. My next question to you is, what is the legal basis for the objection? I'm going to unmute so you can answer. Go ahead, sir.
I've known 2-year-olds
You need to turn around.
who
so I
behave
can
better
hear
than
you.
him.
Part of the issue is he's also not facing the microphone.
I
and
agree.
so I need to hear him, and he needs to turn around.
People don't like hearing this, especially in the modern political context. And this isn't a
Mr. Brooks,
political
I'll ask you
channel
once again, what is the legal
by any
basis
means,
for
but
your objection to the jury instructions?
there are societal problems. One of my closest friends in law school did a research project on the school to prison pipeline
What is the
in
legal
the
basis for your
native
objection to the jury
populations
instructions?
here in Utah. And it's a terrible problem.
I can't even hear what she's saying.
And it does lead to
You want your headset?
further problems down the
Mr.
line
Brooks, I can hear the deputies
because
over
they've
there.
been
I know they can hear
institutionalized.
me. That's been
They
confirmed. There is
are
the headset
labeled
available to you
criminals.
should you wish to use it. If you can't hear, I would ask that you put them on.
He objects.
Just put it down.
I'm able to hear. He said to the deputy, put them down. I don't want them. All right, I'm going to mute once again so I continue with my record. He did not answer.
Context is
question,
usually
was
the
legal
first
basis
thing
for the
ignored,
objection. I asked that question 3 times.
not
based
just
upon
in
that
criminal
non-response.
context
His
either.
objection is noted for the record, and I will approve the preliminary jury instructions that are on file with the court. Obviously, they'll be uploaded once I read them, but
I'm sure he objects to them, but I wonder if he read the jury instructions.
Before I turn to the motion for reconsideration, you raised this earlier, at least the topic of it. Mr. Brooks presented a filing to the court this morning. I asked the bailiffs before the case was called at 8:30
Yes.
if Mr. Brooks had any paperwork, and to ask
And this
him
is
if he had
why
any
it's
filings. He
important
then provided this
to
piece of paper.
be on top of the
and
nurture
it was
element
photocopied. Actually, it was
from a very
date
early
stamped,
age.
then photocopied for the parties. It may have already been scanned in, I'm not sure, but it certainly will be. I've had an opportunity to review this document. Based upon my review, I don't believe any response is even required. It's his affidavit. He's providing certain disclosures, but there's nothing about that that requests any relief from the court. Certainly no legal statutes or constitutional provisions are referenced. To me, it just looks like an objection that he's filing, and that will be, of course, noted for the record. Attorney Opper, anything you would want to add to the record on this, any position you are taking?
No, I also viewed this as, because he labeled it objection by affidavit, I think my interpretation is he was trying to make a record for appeal that he objects to the court's previous ruling.
Once again,
I
sovereign
don't think there's
citizens
anything
and
the
their
court needs to do with
affidavits.
this document at this time.
All right, thank you. Then we'll move on to the motion for.
I'm reminded of
reconsideration. And again,
liar,
I'm
liar,
keeping
though.
Mr.
Objection.
Brooks muted so that I can
What's your
get
reason?
through this process
devastating to
orderly,
my case.
efficiently. When necessary, I will unmute him if the court has questions.
Because that's basically what all his objections
Attorney
have been.
Opera, I have read
Objection.
through the
I don't like this.
motion. Is there anything you want to add to what you have put in your filing?
Only one other observation, Your Honor, that since I filed that, the events of the last couple of days, I think further support my request. Not that the defendant's behavior in the courtroom has anything to do with the broadcasting of victims and witnesses, but I think the stress that is going to be placed upon them potentially by Mr. Brooks' behavior will be additional challenge to them as they testify. And so not having their faces displayed, I think, would help ease some of that tension for those individuals.
I definitely have sympathy for the victims.
Mr. Brooks, my first question to you
witnesses.
is,
And the jury.
do you have a position on the state's
even the judge.
request in their motion for reconsideration? I'm looking for a yes or no answer. If you, I'll unmute and provide that to me. Go
I
ahead.
didn't hear what they said. I just put the headphones on, so I didn't even hear what she said.
That sounds like a you
So
problem.
it's a written document that was filed and you were provided a copy of that yesterday. We took a recess yesterday so it could be served upon you. If you haven't read it, that's your choice. What I'm asking you is, do you have any
Yesterday, he
position on
held
their
his
request
laminated
for this court to
objection
reconsider
sign just constantly. It was just
the denial of the court's, the denial of the state's request to prohibit the photography and video recording of victims and witnesses, and specifically their faces while they testify.
A ruling was already, we already talked about that. You already ruled that the victims and witnesses will be shown. That was already ruled on.
they
You are
discussed
correct,
it
but they
last
filed a
week.
motion for reconsideration. That's the document.
But
that
one of the
was
judge's
provided to you
big
yesterday.
concerns
I'm
was
asking if you have any
Zoom and the court's
position
cameras,
on the request that I reconsider my ruling.
court TV
Yeah, it was,
Which is
everything's supposed to be public.
recording
this.
this
is a public trial.
can actually position their cameras
I
to
don't
satisfy
understand
the
why
state's
There
motion.
would be even the need to reconsider what you already ruled on at this point, as far as to that particular issue.
I take your,
It's a public trial. It's a public trial. Anybody can essentially watch the trial.
His argument last week was,
And like I said, as far as
if the victims don't want to be
technology that we have now,
broadcast in
they have to be sworn in by
what
name.
is the second most difficult moment of their
In
life,
itself makes them easy to.
they should
if
just not
somebody
testify.
Wanted to pull
There's
them
plenty of
up and
other
find them or
witnesses.
find out who was testifying at any given time testimony is given. It'd be pretty easy for them to be found and to be seen. So I mean, that's just the age we're in anyway, as far as with social media and Google and all these different things. We got
Even
all
if
this
you
technology basically
ignore
at our fingertips.
What he's accused
So
of,
I don't
his
understand
behavior, his attitude toward the
how it
victims.
needs to be changed at this point when it was already ruled.
I
that
really
this is a
find
public
him
trial. There's
despicable.
going to be a lot of things that are going to be shown. Why not keep everything public the way that it's intended to be?
Or as Daffy
And
Duck would
because of the
say,
fact that you've already ruled on it,
despicable.
made that on the record. Let's keep it the way it is.
All right, thank you, Mr. Brooks. I appreciate your legal analysis of that and your factual analysis of the prior ruling that this
Legal
court gave. I
analysis.
thought you did an excellent job making some very good points, many of which I relied upon previously.
She praises him for his excellent job.
There is a mechanism in the law for a party to bring a motion for reconsideration. Essentially, it requires that the party bringing the motion provide some new information or rely on an argument that the court aired as a matter of law in its prior ruling. The decision that I made previously and the decision that I make here today is one that is vested with the sound discretion of the court. I would note the state does rely upon a case. The case is not new, so it's clearly something that was in existence at the time of the prior motion. That's Estes versus State of Texas. It's 381 US 532, but I would note it's from 1965. In 1965,
It was very
I would
loud.
say even in the 1980s here in Waukesha County.
And I don't know what it
really a
was.
presumption that cameras not be allowed in courtrooms at all. We have moved vastly away from that over the course of the last couple decades, and certainly since 1965. I am certainly mindful of the potential
So whatever it was, I
that it may
apologize.
cause for victims and other witnesses to come into court and testify and to have their images broadcast as this trial is broadcast, not just locally, but nationally, and frankly, anywhere in the world, anyone with a computer would want to watch. I would note, though, that prior to the point
I
in
frequently
time when
watch
this
Artie's
case
corporate
came to
fiction,
trial,
and he
this
does the
court
jump scares for
took
donations.
significant efforts to keep
That was certainly not my
victims' names
intention.
private. There's a victim key that is on file. This court signed an order and even required Mr. Brooks to not disclose that information. That was one of the conditions set when bond was initially set. Now, that was by a court commissioner, of course, but that's still a ruling that this court adopts. In addition, I believe I've done up to this point everything that I could to preserve their privacy. I don't frankly want to create an issue that could be an appellate issue. I think this potentially could be that if I limit the capturing of victim and witnesses' images. I'm aware of Marcy's law. Certainly aware of the provisions that the state cites. But the fact remains, the time has now come for this trial to be conducted. This is a public trial. The right to a public trial is not only for the defendant, but the state, but the public. All of the names are a matter of public record. This court obviously went through all of the names of the witnesses during the jury selection process.
Marcy's
In
law
the jury instruction,
is the
names
Victim
of all
Bill
the
of
victims
Rights.
will be read. The state agreed that it was time to put that information in a public document and on the
victims
record
of crime
because the time for
have
trial
equal
has
constitutional
come.
rights on the same level as those
The
accused
cameras
of
in the
crimes.
courtroom not only facilitate the viewing of a public trial where anyone could walk in to this courtroom, space permitted, to watch, but it facilitates victim rights as well. And that is because there are a large number of victims in this
Don't
case.
tell anyone.
This court
But
could
he's
not
one of the 3
have
people
all the
who
victims and the
inspired
public
me
and
to
the
start
media
a
who
YouTube
wanted
channel.
to be here present.
But that's our
Frankly, I
secret.
think it's because of how this court has allowed the proceedings to be live streamed that we don't have even a full courtroom here today.
He
There
is,
no
even though
doubt
she's
this
giving
case
him
has
what
received
he
great
argued for.
public
He won this
interest.
motion.
But this is a case that the state brought charges, and rightly so. I understand it won't be easy. It may be messy. It may even be stressful, but it's important to the integrity of these proceedings, the perception of how things are conducted in this courtroom, that all witnesses, that all victims, with the exception of the one thing I accepted previously, be viewed in its fullness to the public. I maintain the exception for juvenile witnesses. They are in a special category as minors, and they, of course, if and when a juvenile witness testifies, may only be captured from these shoulders down. Their faces are not to be broadcast. Again, I am not unmindful of the impact, but in my humble opinion, the right to a public trial supersedes the other provisions, and especially in a case such as this, it's important. I would add to the record some of the points Mr. Brooks made. Not only are these names all a matter of public record, the technology that we have at our fingertips, there's Google, there's social media. It's very easily to identify these individuals and search for them in other ways.
I
would
did have
also
to look
add
it
that
up.
There have been a number of news reports, media accounts, newspaper articles.
I spelled it with a
about
C,
victims,
but it's
naming them.
Marcy with an S.
I'm aware of one such broadcast this morning on Channel 4. I cannot presume that all victims, all witnesses want this. And I want to keep this trial going, and that's what we will do. So the request is denied.
10:12 in
All right,
Wisconsin
I
right now.
believe, let me just get back to my.
I wonder if
first
they'll
note
get
that
to
I had
opening
for this morning,
statements
that we
before lunch.
covered all of the outstanding issues.
I sure hope they do.
If I may, I don't want to interrupt, but I did not hear if you, I was kind of overhearing that you addressed the filing that I filed this morning. I didn't hear exactly what was said. I'm just making sure that you know that I'm not trying to interrupt. I just want clarification on what I may have missed.
I'll tell you what I ruled previously. I've reviewed
The
the
other was
filing. It's entitled objection by
Schrodinger's cat.
affidavit to the state's response
And
in the court's opinion and
Unfortunately,
order.
you
The
definitely can't
defendant's
tell
disclosure
him.
statement by affidavit. It's an affidavit. It does not request any relief from the court. I have interpreted what you have filed as an objection to be noted on the record. It has been accepted. It has been filed, and that your objection is noted. The court need not take any specific action as it relates
Yes.
to it. I further indicated that, again, no relief was requested, but also there's no statutory or constitutional or law that you cite to that I could even interpret as a request for relief. So that's how I'm going to address that filing, sir. It's noted for the record.
Agreed.
Can I say one thing about that?
Quickly, sir. I need to keep
I
going.
was
I was
setting
setting up my
filing
channel
that paperwork
around the time
I
of
would
his
say
death.
pursuant to federal
And
rules of criminal procedure under
even
Rule
though I never met him,
12.4 about the disclosure
it had a
statement.
big impact on me and
All right,
delayed
Note
So I
that
will-
for the
my
record, sir, that it
starting
was
my
not in your
channel
filing.
by quite a while.
So that's a judicial determination, Your Honor?
I believe I had one other thing.
Everything the
Oh,
judge
I
does
did
is
want to put on the
a
record,
judicial
and that
determination.
is when we were testing the audio, I did advise the sheriff's department to let Mr. Brooks know, to ask him on my behalf if he wanted to come back into this courtroom. My understanding is he declined.
No, that is not accurate, Your Honor.
Mr. Brooks,
The reason,
Mr. Brooks,
I would just want it,
hold on, I'm gonna
For the
mute you
record.
for a second unless you stop and listen to me.
I just heard what you said, but I just.
I'm not
want to correct
asking
the
for a
record because
response,
it's not-
sir. Mr. Brooks?
It's not. it's
Okay,
not
you're
accurate, Your Honor.
interrupting. Hold on. You're interrupting me, sir. I wasn't looking for a response. I'm happy to ask you the question myself on the record for you to answer it. I will give you the opportunity to come back into this courtroom. You have demonstrated that you can make cogent, coherent, articulate arguments on the record. You just did that. You've been respectful for the time being. I will ask you, sir, do you want to come back into this courtroom? You've been unmuted to answer that question.
Not until I can receive medical treatment for the bruise that I have on my arm and the cut. You just said a while ago on the record that you cannot see blood. That's because I wiped it on my pants and you can still see the blood in the cut and a big bruise right here on my arm. I was told that the nurse would be coming in to see me. And then I was told, no, she's going to come at the next recess, which we just took. I know it was technical difficulties why you called the recess, but that was more than enough time for me to at least be seen, at least get the cut cleaned out and get it bandaged, at least at minimum that, and for somebody to look at this bruise. That was my position on why I was not yet ready to come back into the court.
We need to delay the trial. Needs to be addressed. He's got a boo-boo.
All right, Mr. Brooks, I understand your request. I'm denying the request to take
to
take a break at this time.
My assumption would be
I didn't ask for a break. I was just saying that at
deputies
the time that there was the technical difficulty
holding his arm too hard, removing him from the court.
Before you even called that, Your Honor.
But I don't know.
I was told that a nurse was coming in.
He might have done it himself.
But then when you called the recess for the technical difficulty, I was then told that I would have to wait until another recess to be able to be seen by the nurse, which my thing was, I
Mr.
wanted
Brooks,
to
you've
get
made
seen
your
by the
record,
nurse.
okay? I don't need you to go further with that. You've made your record. I'm going to mute you for the time being. I want you to be aware, sir, I was advised regarding the cut. The bruise is new information. I made a determination that you would be seen at the next appropriate break. From my perspective, a small cut and a bruise is not going to hold up the start of bringing the jurors in and advising them of the preliminary jury instructions. If that means the next break we take is for lunch and that's when you are seen, then that's what will happen. So
his cut
I don't
does
think I've overlooked
nothing
anything,
to stop him
Attorney
from
Albert, but
assisting in his
anything you have on
defense.
your list.
Nothing else on my list, but we want to give Mr. Brooks one more opportunity to change out of his orange jail uniform, excuse me.
That I would give him an opportunity.
This is Shakespearean
to do.
because it's much ado about
Mr.
nothing.
Brooks, would you like to go back and change into your suit?
My position has not changed whatsoever, and it will not change, as it is my right to come into court how I would like to. Just like I should be awarded the right to be present for every proceedings in this trial.
All right, I'm muting him again. I note your objection. I will take that as a clear indication you do not want to go back to the jail to change into street or civilian clothing, that you are exercising your right to dress
on his part.
In the jail.
Terrible
attire.
idea.
All right, then with that, I am going to just take a short recess just to have the jurors brought in.
Do you think it'll be Snoopy?
Needs his objection sign.
We'll make sure he has it.
Thank you.
I think he wants a Snoopy Band-Aid.
Let me actually go back on the record for a second. Mr. Brooks, when the jury comes in, I am going to read through the preliminary jury instructions. Since those have been approved by the court, if you happen to raise your sign, I'll note it for the record, but I'm not going to ask you for any type of argument on that because we've already had that opportunity to do so. It will take me some time to read through the instructions. I don't know if that will take us to the lunch hour or not.
Opening statements will be after lunch.
Potentially prepared to go through its opening. Mr. Brooks, if we do get to that point where the state is giving its opening and you have an objection, you need to write down the objection in addition to raising your hand, and I will rule on the objections after the closing statement. So you must write down
Not a
the
princess.
basis for the
It'll be
objection
Tinkerbell.
and what you're
Tinkerbell.
objecting to, in addition to holding up your sign. That's the procedure that we will follow. Right now, we're on a short break until the jury comes in.
And he holds up his objection sign. I don't know what he's objecting to. Although he does have a continuing objection to everything. And I hope this is a short recess. But as the judge mentioned, this recess, at the end of it, they are going to finally bring the jury in. Which I'm guessing it's 10:21 here in Utah, or 10:21 in Milwaukee, 9:22 now here in Utah. I'm guessing 10:30 roughly. So, 9-10 minute break. They'll bring the jury in. And as the judge mentioned, that's when she'll read the preliminary jury instructions. Generally, that's not super exciting. Once again, it's housekeeping. But it's not everything that's important is exciting. And this is very important. Because the jury needs to know what's expected of them. They need to know beforehand, for example, that they're not supposed to discuss the case. They can't go home and Google the case. They can't discuss their opinions on the case with other jurors until deliberation at the end of the case. So it's not exciting, but it's essential. Generally, it's not going to take super long. It's the pre-deliberation jury instructions that take forever. I know Static mentioned that he's been watching the Trevor Summers case. Law Talk with Mike covered it last month, and then sentencing was on Monday. But the jury instructions for that before deliberations really took longer than the jury deliberations almost. But that shouldn't be the case today because, once again, it's the preliminary. It's not reading out what all the elements of every charge is and how they're supposed to go about it. And once they're done with that, there shouldn't be any more motions this morning. It should go straight into the opening statements, unless it does lead into lunchtime. But if it leads into lunchtime, then coming out of lunch, it'll go straight into it. And you'd think, as a true sovsit, he should refuse to cooperate. But sovereign citizens, if they're anything, it's inconsistent. Because, I mean, he has no choice. He's in custody. But sovereign citizens will receive a summons for their traffic ticket and show up to court. If the court has no jurisdiction, why show up at all?
Gentlemen of the jury and everyone may be seated. I appreciate your patience as the court addressed.
And that was faster than I thought.
With the parties this morning.
I said
I'm
10:30.
going
It's
to read through the
10:25.
preliminary instructions at this time. Please pay careful attention. Just as a reminder, they're not something you need to memorize. Ultimately, at the close of the case, a very similar set of instructions are provided to the jurors to take back to the jury room. Before this trial begins,
gonna
there are certain instructions
be
you
mostly
should have
quiet.
to better understand your functions as a juror and how you should conduct yourself during the trial. Your duty is to decide the case based only on the evidence presented at trial and the law given to you by the court. Anything you may see or hear outside the courtroom is not evidence. All people deserve fair treatment in our justice system, regardless of their race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. People make assumptions and form opinions from their own personal backgrounds and experiences. Generally, we are aware of these things, but you should consider the possibility that you have biases of which you may not be aware, which can affect how you evaluate information and make decisions. You must carefully evaluate the evidence and resist any urge to reach a verdict that is influenced by any bias for or against any party, witness, or attorney. Personal opinions, preferences, or biases have no place in the courtroom, where our goal is to treat all parties equally and to arrive at a just and proper verdict based on the evidence. Do not begin your deliberations and discussion of the case until all the evidence is presented and I have instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This
She's saying
order
it
is
better
not
than how I
limited to
ad-libbed
face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about this case or your experience as a juror. We will stop or recess from time to time during the trial. You may be excused from the courtroom when it is necessary for me to hear legal arguments from the parties. If you come in contact with the parties, lawyers, or witnesses, do not speak with them. For their part, the parties, lawyers, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities to share any information about this case. For example, do not communicate by telephone, blog post, email, text message,
What's a
instant
blog
message,
post?
social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by other means. If anyone does so despite you telling them not to, you should report that to me. I appreciate that it's tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After the trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules,
I
they
thought
should
she
report
said
it to me.
block.
If jurors do not comply with
BLOCK.
these rules, it could result
You
in
heard
a
it
new
better than
trial
I did.
involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. You are not required to, but you may take notes during the trial, except during the opening statements
True.
and closing arguments. The court will provide you with the materials. In making notes, you must be careful that it
Not
does
that
not
I've had
distract you
run-ins
from
with the
carefully
law.
listening to and observing the witnesses. You may rely on your notes to refresh your memory during your deliberations. Otherwise, keep them confidential. After the trial, the notes will be collected and destroyed. You will not have a copy of the written transcript of the trial testimony available for use during your deliberations. You should pay careful attention to all the testimony because you must rely primarily on your memory of the evidence and testimony introduced at trial. During the course of a trial, the parties may refer to or use police reports with witnesses. Normally, these police reports will not be provided to you. If you are not provided with a police report, you should use your collective memory regarding any reference to police reports. The defendant has a constitutional right to represent himself. I have advised the defendant that the same rules apply whether a lawyer acts for him or he acts for himself.
Probably the
defendant
most
has
important
decided to
section.
represent himself, and this decision must not influence your verdict in any manner. This court is tasked with ensuring the orderly administration of the case. My job includes making sure that the defendant's rights are protected, making sure that the state and the defendant can present their respective cases in a coherent and orderly fashion, and that victims, witnesses, and the public are appropriately treated in the courtroom. All parties in the courtroom, including the attorneys, the litigants, witnesses, the judge, the jurors, and those in attendance are expected to conduct themselves appropriately and in a manner that avoids creating disorder or disruption, as well as conduct themselves in a manner that demonstrates sensitivity to the necessity of preserving decorum and the integrity of the judicial process.
He'll have a hard time with
At
that
the
one.
moment, Mr. Brooks is appearing from another courtroom. This must not influence your verdict in any manner. Evidence is defined as
It's going to be a
first,
month of
the
standing for
sworn
him.
testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts
Yes.
to which the lawyers have agreed or stipulated or which the
Yes.
court has directed you to find.
He needs a major attitude
Anything you
adjustment.
may have seen or heard outside the courtroom is not evidence.
This is important.
You are to decide the case solely
What is
on the
and isn't evidence.
offered and received at trial.
Like him wearing orange
It
is
is
not
not
evidence.
necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience.
Despite what TV would have you think,
Evidence
circumstantial
is not necessarily
evidence
better
is
or
frequently
worse than
the best
direct
evidence.
Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offenses before you may find the defendant guilty.
It drives me nuts on Law and Order.
In reaching your verdict,
They have no case.
examine
It's all
the evidence
circumstantial.
with care
Great.
and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty.
Notice, it's not all
The burden of
reasonable doubt.
establishing every fact necessary to constitute guilt is upon the state.
It's a very high bar,
Before you can
but it's
return a
not
verdict of guilty, the
100%
evidence
certain.
must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis
I do that
consistent
too.
with the defendant's innocence, you should do so and return a verdict of not guilty.
Luckily, I'm on my computer
The
now,
term
so
reasonable
the
doubt
chat's
means
just
a
open.
doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence.
I like that she's
It means such a
describing what
doubt as
reasonable
would cause
doubt
a
is.
person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt.
I like this
A reasonable
instruction.
doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth.
Well put.
Parties for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence, which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be
That's
received
good,
over
since
the
he
objection
constantly
of a
objects.
party, the court
Sign.
is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and of the weight of the evidence. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence.
You've
An
got to
exhibit
overcome
received is
the
evidence
law
whether
and
or
order
not it goes
effect.
to the jury room. Remarks of the parties are not evidence. If the remarks suggest certain facts not in evidence, disregard the suggestion. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is,
No
the
clue.
believability of the witnesses
He
and of the
announced
weight
it
to be given to their testimony.
last week when he fired his
In
attorneys.
determining the credibility of each witness and the weight you give to the testimony
And I
of
don't know if
each
he's a true
witness,
believer
consider these factors.
or a soft set
Whether
of
the witness has an
convenience.
interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin,
I think most
religion,
are
age,
soft sets by
ability,
convenience.
gender identity, sexual orientation, education, income level, or any other personal
Or
characteristic.
fake gurus.
There's no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. The defendant is charged with 6 separate counts of first-degree intentional homicide, use of a dangerous weapon. The first count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Virginia Sorensen with intent to kill that person and while using a dangerous weapon. Contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes.
I would be
The
satisfied
second
with
count of the
exponential growth.
information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Leanna Owen.
If that happened,
with
though, I'd
intent
have to
kill that
figure out how to
person
slow the
and while
chat.
using a dangerous weapon, contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The third count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Tamara Durand with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and
Will
939.63
do.
sub 1 sub B of the
And
Wisconsin
that's why I try to
statutes.
highlight your
The
comment.
fourth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jane Coolidge with intent to kill that person.
Or
and
I'll
while
have to
using
make you a
dangerous
moderator.
weapon, contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The fifth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Wilhelm Hospel with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub B of the Wisconsin statutes. The sixth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jackson Sparks with intent to kill that person and while using a dangerous weapon, contrary to section 940.01 sub 1 sub A, 939.50 sub 3 sub A, and 939.63 sub 1 sub
It's
B of the
usually me
Wisconsin
that's the
statutes.
sarcastic
The
jerk in the
defendant
comments.
has entered a plea of not guilty
I usually follow
to
the
each
rules,
one of
though.
these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. First degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of any count of first degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present.
I
with
just have to
respect
figure out how
that
to make
count.
that happen.
One, as to each count, the defendant caused the death of the victim named in that count. Cause means that the defendant's acts was a substantial factor in producing the death. Two, as to each count, the defendant acted with the intent to kill the victim named in that count. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed.
If I
The
got,
act need not be brooded over, considered, or reflected upon for a week,
I
a
would be
day, an
ecstatic
hour,
to have
or for even
10,000
a minute.
trolls.
There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant,
I already
the
said
state
they
is
should
not
put a bag
required
over
to
his
prove
face.
motive on the part of
So,
the defendant in order
An
to
objection
convict.
bag works.
Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all the circumstances. The information alleges not only that the defendant committed the crimes of first-degree intentional homicide, but also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner it
I
is
figured
used
it
or
out.
intended to
You're
be
both
used,
mods.
is likely to produce death or great bodily harm.
Don't abuse it.
Great bodily harm means serious bodily injury. If you find the defendant guilty of a count of first-degree intentional homicide, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? Before you may answer this question, yes, you must be satisfied beyond a
Don't
reasonable
time me
doubt
out.
that the defendant committed the crime of first-degree intentional homicide while using a dangerous weapon. If you are not so satisfied, you must answer the question, no. If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count one, you should find the defendant guilty of first-degree intentional homicide as charged in count one. If you are not so satisfied, you must find the defendant not guilty as to count one. If you find the defendant guilty of count one, you must answer the following question, yes or no.
And with me looking off to the
Did the
side, I'm
defendant
trying to
commit the
figure
crime
out
of
the
first-degree intentional
inner workings
homicide
of
while using a
YouTube
dangerous weapon?
during a live stream.
If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count
That's what
two,
my instructions
you
would
should find
be.
the defendant guilty of first-degree intentional homicide as charged in count two. If you are not so satisfied, you must find the defendant not guilty as to count two. If you find the defendant guilty of count two, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count three, you should find the defendant guilty of first-degree intentional homicide as charged in count three. If you are not so satisfied, you must find the defendant not guilty as to count three. If you find the defendant guilty of count three, you must answer the
Thank
following
you.
question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon?
Like I said,
If you are
I'm shocked
satisfied
to have
beyond a
any
reasonable
live
doubt
viewers.
that both elements of first-degree intentional
Sounds
homicide
corny.
have been
I
proved as to
really
count
appreciate
four,
both of
you
you.
should find the defendant guilty
And any
of
of you who
first-degree intentional
watch this later
homicide as
who are
charged
not
in
live.
count four.
I appreciate all of
If you
you.
are not so satisfied, you must find the defendant not guilty as to count four. If you find the defendant guilty of count four, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 5, you should find the defendant guilty of first-degree intentional homicide as charged in count 5. If you are not so satisfied, you must find the defendant not guilty.
I don't
As
know
to
why
count
when I
5.
have my computer in front of me, I use my
If you
phone.
find the defendant
Google
guilty
stuff.
of count 5, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that
You've got
both
me.
elements of first-degree intentional homicide have been proved as to count 6, you should find the defendant guilty of first-degree intentional homicide as charged in count 6. If you are not so satisfied, you must find the defendant not guilty as to count 6. If you find the defendant guilty of count 6, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? The defendant is charged with 61 separate counts of first-degree recklessly endangering safety, use of a dangerous weapon. The 7th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin,
I
did
don't know.
recklessly endanger the safety of Nicole White under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub F,
I have a
and
feeling
939.63
as they go
sub
forward,
1
it
sub
might
B
start
of
at
the Wisconsin statutes.
10 o'clock Eastern, 9 Central.
The 8th count of the
Unless they have
information in
pre-trial.
this case charges that
Well,
Darrell E. Brooks, on or about Sunday,
jury
November
motions.
21 of 2021, on Main
Housekeeping.
Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Eleanor Anders under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 9th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Sasha Catalan Castillo under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
I've never
The
heard
10th
that
count of the
term,
information in this case
but I love
charges
it.
that Darrell E. Brooks,
And
on or
hello.
about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Maura Gilchrist under circumstances which show utter disregard for human life and while using
We
a
decided
dangerous
it would be a
weapon,
bag to go over his
contrary
head.
to section 941.30 sub 1, 939.50 sub 3 sub
But I like the
F,
spinning
and
sign.
939.63 sub 1 sub B of the Wisconsin statutes. The 11th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Justin Gullickson under circumstances which show utter disregard for human life and while
Was it in
using a
the
dangerous
OG
weapon,
Law and
contrary
Order, or
to
was it
section
SVU?
941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 12th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Harry Guilfoyle under circumstances which show utter disregard for
It's
human
been a
life
while since
and
I've
while
watched
using a
the
dangerous weapon,
original.
contrary to
or
section
SVU.
941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 13th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Aiden Loughran under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub F,
They
and
can be
939.63 sub
entertaining,
1 sub B of the Wisconsin
but
statutes.
they can also
The
be
14th count of the
problematic.
information in this case
So
charges that
you need to go
Darrell E.
in
Brooks, on or
understanding
about Sunday,
it's
November
fiction.
21 of 2021, on Main Street in the city of Waukesha,
I'll have to go back
Waukesha
and
County,
watch that
Wisconsin,
episode.
did recklessly endanger the safety of Theo Maza under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 15th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Tyler Pudliner under circumstances which show
And
utter
good news,
disregard for human life
in preparation
and while
for the
using a dangerous
exponential
weapon,
growth, I figure I'll need
contrary
it
to
by
sections
week after next.
941.30 sub 1,
I figured out slow mode.
939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
I may have screwed up the first
The
half
16th
hour,
count of the
but I'm figuring it
information
out.
in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the
Sometimes
safety of Connor Tank under
mindless
circumstances which show utter disregard for human life
entertainment
and while using a dangerous
can be
weapon,
satisfying.
contrary to sections 941.30 sub 1, 939.50 sub 3 sub F,
Enjoy
and 939.63
a
sub
continued
1 sub B
plot
of the
as well.
Wisconsin statutes.
I've been watching the new Star
The
Wars show
17th count
Andor,
of the information in this
and I'm
case
loving it
charges
because
that
it is that
Darrell E.
slow
Brooks, on or
burn.
about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Eric Teagues under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub
It's going
F,
to take a long
and
time to read through all these
939.63 sub 1 sub B
70
of the
counts.
Wisconsin statutes. The 18th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of
Only
2021,
50 or
on Main
60 counts
Street
to
in the
go.
city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Adelia Mafioli under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30
It creates an
sub 1,
unrealistic
939.50
impression
sub 3
of
sub
the
F,
legal
and
system,
939.63
especially about the
sub
speed
1
of
sub B of the
cases.
Wisconsin statutes. The
And
19th count of
that's
the
one of the reasons
information
why
in this
reading the
case
jury
charges that
instructions
Darrell
is
E.
so
Brooks,
important
on or
in a
about
case
Sunday,
like this.
November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Kelly Graybow
Is that
under
that
circumstances
Amazon
which show
Lord
utter
of the Rings
disregard for life
series?
and while using a dangerous weapon.
I haven't watched it at
Contrary
all.
to sections
My fandom
941.30
is
sub 1,
mostly Star Wars.
939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
Thank you.
The 20th count of the information in this case charges that Darrell E. Brooks on or about Sunday, November 21 of 2021 on Main Street in the city of
I think
Waukesha,
it's important
Waukesha County, Wisconsin,
to come
could
from the
recklessly
judge.
endanger the safety of Josh Craner under circumstances
It
which
wouldn't
show
have
utter
the
disregard
impact
for human
if,
life
say,
and while
her
using a
clerk,
dangerous weapon, contrary to
were to
sections
read it.
941.30 sub 1, 939.50 sub 3 sub F,
And at the end,
and
they will receive a
939.63 sub 1
hard
sub B
copy
of the
of the
Wisconsin statutes.
final jury
The 21st
instructions
count of the
when they go back to
information in this
deliberate.
case charges that Darrell E. Brooks on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Riley Rogers under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50
I don't
sub
know
3
that I've
sub F,
seen the
and
earliest
939.63 sub 1
seasons.
sub B of the Wisconsin statutes.
I think the earliest I've seen is the Lenny Briscoe era, but I know he wasn't sort of the first generation.
The 22nd count of the information in this case charges that Darrell E. Brooks on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha,
I like that the
Waukesha County,
objection
Wisconsin,
sign is tucked
did
into his
recklessly endanger the
waistband.
safety of Caden Rogers under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 23rd count of the information in this case charges that Darrell E. Brooks on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Tucker Sparks under circumstances which show utter disregard for human life.
I don't know that
and while
name,
using a dangerous weapon.
so I don't think I
Contrary
did see
to
it.
sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 24th count of the information in this case charges that Darrell E. Brooks on or about Sunday, November 21, 2021.
Your
on
phone
Main Street
realizes
in the city of Waukesha,
4 in the
Waukesha County,
morning
Wisconsin,
or whatever it is
recklessly
there in New
endanger the
Zealand.
safety
It's
of
tired
Isabella
too.
Bartelt under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of
Don't
the Wisconsin
apologize.
statutes.
I'm shocked you're
The
awake right
25th
now,
count of the information
really am,
in this case
and I appreciate it.
charges that Darrell E. Brooks on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Yuritsa Sarah Montez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 26th count of the information in this case
I
charges
understand
that
why they
Darrell
don't,
E. Brooks on or about Sunday, November
but I kind of
21,
wish that she'd
2021
lump
on Main
the
Street in the city of Waukesha,
Well,
Waukesha County,
same
Wisconsin,
charges
did
into a
recklessly
group.
endanger the safety of Samantha Colo under
like I said, I
circumstances
understand
which
why
show
she
utter
doesn't.
disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 27th count of the information in this case charges that Darrell E. Brooks on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Madison Hollingsworth under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 28th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did
I'm
recklessly endanger the safety
guessing
of Mackenzie Hollingsworth under circumstances which show utter disregard for
that it
human
could go
life
until
and when
about
using a
4
dangerous weapon,
o'clock,
contrary to sections 941.30
which would be 5 o'clock
sub 1,
local time in
939.50
Wisconsin.
sub 3 sub F, and
Although
939.63 sub 1 sub B of the Wisconsin statute.
they could run
The
a little
29th
late,
count
or
of the
they could
information in this case
call it a little
charges
early
that
for the day
Darrell E. Brooks, on or about
if it
Sunday,
makes
November
sense
21
to
of
not move on
2021,
to the next
on Main
witness.
Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Mitchell Lampine under circumstances which show utter disregard for human life and while using
I guess
a
you
dangerous
live up to your
weapon,
name.
contrary to
Starlight
sections
would
941.30
be
sub 1,
nocturnal, just like me.
939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 30th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Kathleen Peelmeyer under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 31st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Julia Shulekow under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 32nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Olivia Stover under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 33rd count of the information in this case charges that
The
Darrell E. Brooks, on or about Sunday,
941.30
November 21 of 2021,
recklessly endangering
on Main
safety
Street in the city of Waukesha,
is a class
Waukesha
F
County, Wisconsin,
felony.
did recklessly endanger the safety of Jennifer Stover under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 34th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin,
And
did
a class
recklessly
F
endanger the
felony
safety of
is
Jesselyn
punishable
Torres
by
under
a fine
circumstances which
not
show
to
utter
exceed
disregard for human life and while
$25,000
using a dangerous weapon,
or
contrary to
imprisonment
sections
not to exceed
941.30
12
sub
years
1,
and 6 months
939.50
or
sub
both.
3 sub F, and 939.63 sub 1 sub B of the Wisconsin statute.
In case you were wondering.
The 35th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Alice Uriel under circumstances which show utter disregard for human life and will use
He's
a
got the
dangerous
forehead for a
weapon, contrary
tattoo.
to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
It can be per
The
charge,
36th count of
but
the information in this case charges that
it could
Darrell E.
be
Brooks, on or about Sunday,
concurrent,
November
meaning
21 of
he
2021,
receives
on Main Street in the
a
city of
12-year
Waukesha,
sentence
Waukesha County,
for each of
Wisconsin,
these
did
charges,
recklessly endanger the
but
safety of
they're all
Charlotte
served at the
Darrell
same
under
time.
circumstances which show utter
But
disregard
his crime
for
was so
human life
heinous that
and while using a
I
dangerous weapon.
see
Contrary
many
to
of the charges
sections
being
941.30
consecutive, meaning one
sub
after
1,
the other.
939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes.
And if he's convicted of the top
The
counts,
37th
those are
count of the
life
information
imprisonment,
in this case
no
charges
question.
that Darrell E. Brooks, on or about Sunday,
Manslaughter,
November 21 of 2021,
I mentioned earlier, is a
on
Class
Main
D
Street in the city
felony,
of Waukesha, Waukesha
and that's
County,
up
Wisconsin,
to
did
25
recklessly
years
endanger the
per
safety
count.
of Vivian Uriel under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 38th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Grayson Uriel under circumstances which show utter
Hopefully, I'll
disregard
see
for human
you
life and
soon.
while using a dangerous
If
weapon.
not,
Contrary
thanks for hanging
to
out.
sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 39th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Lola Hospital under circumstances which show utter disregard for human life and while using a dangerous weapon. Contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 40th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Tamara Rosentreter under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 41st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Betty Strang under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50
His behavior is
sub 3 sub F,
definitely
and
going to
939.63
impact the
sub 1
jury.
sub B of the Wisconsin statutes. The 42nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County,
See you
Wisconsin, did recklessly endanger the safety of Maria Alvarez Dominguez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 43rd count of the information in this case charges that Darrell E. Brooks,
I
on or
told you
about
this
Sunday,
wouldn't be the most
November
exciting part.
21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Georgia Romelia Perez under circumstances which show
But I
utter
think we will
disregard for
get
human life
fireworks.
and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 44th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Elliot Hallmark under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1,
They say don't watch sausage
939.50
being
sub 3 sub
made.
F, and 939.63 sub 1
But
sub
sometimes
B
it
of
is
the
important to
Wisconsin
see the
statutes.
inner workings.
The 45th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city
And
of
if you're like
Waukesha,
me,
Waukesha County,
you're
Wisconsin,
probably doing
did
4 other
recklessly
things
endanger the safety of Benjamin
concurrently.
Hallmark under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 46th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of
He's checking his
2021
paper cut.
on Main Street in the city of Waukesha,
Call off the trial.
Waukesha County, Wisconsin, did recklessly endanger the safety of Patrick Heppy under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 47th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Lori Loken under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. For a moment, I just want everyone to stand.
It's important to stand every now and then. Get the circulation flowing. I think the judge realizes it's going to be a long, long trial.
You have a seat when ready. What type, okay.
I don't understand why Law and Crime has gone to the title page. the judge did say you can have a seat when you're ready, so this isn't going to be a long recess. I don't know that it
The
even
48th
counts as
count
a
of the
recess.
information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Marisol Lopez Gutierrez under circumstances which show utter disregard for human life.
I just
and while
gave you a
using
wrench
dangerous
too,
weapon,
John. Don't
contrary
abuse it.
to Sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 49th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Adair Lopez Rebolar under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 50th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21, 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Juan Marquez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 51st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21, 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of David Marquez under circumstances which show utter
I'm
disregard for
curious
human life
about
and while
the
using a dangerous weapon,
legal
contrary
definition
to
of
Sections
utter
941.30
disregard.
sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 52nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of William Mitchell under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 53rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Jason Petchloff under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Section 941.30 sub 1, Section 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 54th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Margaret Pachulis under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to Sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 55th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Yamilet Perales Alvarez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 56th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Alin Perales Alvarez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 57th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of
It's
Ashley
70
Perales
something.
Alvarez under circumstances which
I'm
show utter
actually, the
disregard
reason
for
I'm
human
looking off
life
to my
and while using a
right,
dangerous weapon. Contrary
I
to
think it's
sections
mirrored, so it might look like
941.30
it's my
sub
left,
1,
or it just might be my
939.50 sub 3
perspective.
sub F, and
But
939.63
I'm
sub
looking
1
at the
sub
other
B of the
screen,
Wisconsin
trying to
statutes.
find the
The
criminal
58th count of the
information.
information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Jose Perales Alvarez under circumstances which show utter disregard for human life and while using a dangerous weapon. Contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1
It's
sub B of the
76
Wisconsin
counts.
statutes. The 59th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of
She
Maria
said count
Perez under
59,
circumstances which show utter
so
disregard for
17
human
to
life
go.
and while using a dangerous weapon. Contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 60th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Camila Perez Gonzalez under circumstances which show utter disregard for human life
Approaching
and while using a
11:30
dangerous
in
weapon. Contrary
Wisconsin.
to sections
So
941.30 sub 1,
I'm guessing
939.50 sub 3 sub F,
both
and
opening statements are after
939.63
lunch.
sub 1 sub B of the Wisconsin statutes. The 61st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Isaac Foglia under circumstances which show utter disregard for human life and while using a dangerous weapon. Contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 62nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Deborah Ramirez under circumstances which show utter disregard for human life and while using a dangerous weapon. Contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the
I'm definitely
Wisconsin
getting ready
statutes.
for lunch.
The 63rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Charles Green
And some
under
caffeine.
circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 64th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Lily Green under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, 939.63 sub 1 sub B of the Wisconsin statutes. The 65th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Brindley Harris under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin
I don't know if there
statutes.
will be more
The
instructions
66th count of the information
once
in
they
this
finish the
case charges that
charges.
Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Kelsey Knapp under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 67th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Owen Ricciati under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The defendant has entered a plea of not guilty to each of these charges, which means the state must prove every element of each offense charged beyond a reasonable doubt. First degree recklessly endangering safety, as defined in section 941.30 sub 1 of the Wisconsin statutes, is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of any count of first degree recklessly endangering safety, the state
They
must
can
prove
be
by evidence
entertaining.
which satisfies you beyond a reasonable
I'd prefer
doubt
not to meet
that the
any, though.
following three elements were present with respect to that count. One, as to each count, the defendant endangered the safety of another human being. Two, as to each count, the defendant endangered the safety of another by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss of impairment of the function of any bodily member or organ or other serious bodily injury. 3, as to each count, the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider
Never heard
these
of either of
factors:
those.
what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. The information alleges not only that the defendant committed the crimes of first degree recklessly endangering safety, but also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. If you find the defendant guilty of a count of first-degree recklessly endangering safety, you must answer the following questions, yes or no.
I think my favorite zombie
So actually,
show
one question
is
per
Shaun
count.
of the Dead.
Did the
I'm a
defendant
comedy
commit
person, mostly.
the crime of first-degree recklessly endangering safety while using a dangerous weapon? Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first-degree recklessly
I might check
endangering
it out.
safety.
I've only seen a little bit of The Walking Dead and meh.
While using a dangerous weapon. If you are not so satisfied, you must answer the question no. Let me just read that one more time. Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first-degree recklessly endangering safety.
Is she missing a page?
Tell you what, I'm gonna let you all stand while I figure out if there's a typo in my instructions because I want to make sure I read them correctly. So go ahead and stand while I do that.
Typos happen to the best of us. Not me, of course. It's always my computer's fault if there's a typo. I swear. That's a lot of paper shuffling for a potential typo. But, as I've said, she really dots her I's and crosses her T's. She wants to make sure this is airtight, whatever happens. It would really be awful if the witnesses and victims had to come back for a second trial and go through all of this again. It would just be traumatic. I think a second trial would be worse than the first trial. Luckily, I've never had to experience that. One of the benefits of being a boring person.
All right, go ahead and have a seat. Just so the record is clear, I'm just going to start over with the use of a dangerous weapon part of this instruction. The information alleges not only that the defendant committed the crimes of first-degree recklessly endangering safety, but
She's
also
so
that
thorough.
the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. If you find the defendant guilty of a count of first-degree recklessly endangering safety, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree reckless endangering safety while using a dangerous weapon? Before you may answer the question yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first-degree recklessly endangering safety while using a dangerous weapon. If you are not so satisfied,
It's possible it wasn't
you
so
must
much a typo
answer
as
the
a
question no.
wrong word. Find instead of answer would be a big
If you are satisfied
difference.
beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 7, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 7. If you are not so satisfied, you must find the defendant not guilty as to count 7. If you find the defendant guilty of count 7, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon?
I hope she doesn't go through all
If you are
70
satisfied beyond a reasonable doubt that all three elements of first-degree
of this
recklessly
now.
endangering safety have been proved as to count 8, you should
Lump
find
the
the defendant
like
guilty
crimes
of
together.
first-degree recklessly endangering safety as charged in count 8. If you are not so satisfied, you must find the defendant not guilty as to count 8. If you find the defendant guilty of count 8, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while
Generally,
using
no.
a dangerous weapon? If you are satisfied beyond a reasonable
But
doubt that all three elements of first-degree
judges
recklessly
can be
endangering safety
punished
have been proved as to
for
count 9, you should
egregious
find the defendant
behavior
guilty of first-degree recklessly
or
endangering safety as charged in count 9. If you are not so satisfied, you must find the defendant not guilty as to count 9. If you find the defendant guilty of count 9, you must answer the following
if it's
question,
making the
yes or
wrong
no.
legal
Did the
determination,
defendant commit the
generally
crime of
no.
first-degree recklessly endangering safety while using a dangerous
But
weapon? If you are satisfied beyond a reasonable doubt that all three elements
yeah,
of first-degree recklessly
the
endangering
standard
safety
legal
have
answer
been
is it
proved,
depends.
count
Generally
10,
not.
you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 10. If you are not so satisfied, you must find the defendant not guilty as to count 10.
Some judges, though, it
If
is
you
a
find the
big
defendant
matter
guilty
of
of count
pride
10, you must answer
to
the
not
following
be
question, yes or no.
overturned on
Did the
appeal.
defendant commit the crime of
Others don't
first-degree
care.
recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety
A pattern
have been
could
proved
lead
as
to
to count
removal
11,
from the bench.
you should find the
Definitely.
defendant guilty of first-degree recklessly endangering safety as charged in count 11.
If they've been
If you are not
overturned,
so satisfied,
they're on
you
notice
must
that they were
find
wrong, so they
the
shouldn't
defendant not
find the
guilty
same way
as
in
to
the
count
future.
11. If you find the defendant guilty of count 11, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree
It can lead
recklessly
to a
endangering
public
safety
outcry.
while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree
Which is one of the
recklessly
reasons why
endangering
I don't
safety have been
like
proved as to count 12,
direct
you should find the
elections for
defendant
judges.
guilty of first-degree recklessly
I think
endangering
Utah
safety as
actually,
charged in
this is
count
one
12.
thing Utah does
If you are
right,
not so satisfied, you
have
must find the
appointed
defendant not
judges
guilty as to count 12.
who face
If you
retention
find the defendant
elections,
guilty of count
which are
12, you must answer
unopposed.
the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 13, you should find the defendant guilty of first-degree recklessly endangering safety
But
as
keeping their
charged in
job
count
is
13. If you are
motivation.
not so satisfied, you must find the defendant not guilty as to count 13. If you find the defendant guilty of count 13, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 14, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 14. If you are not so satisfied, you must find the defendant not guilty as to count 14. If you find the defendant guilty of count 14, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable
must have
doubt that
stepped
all
out.
three elements of first degree recklessly
said,
endangering safety have been
don't
proved
abuse
as
it.
to count 15, you should find the defendant guilty of first degree
But being
recklessly
here when
endangering
very few
safety
others
as
are,
charged in count 15.
you get
If you are
privileges.
not so satisfied, you must find the defendant not guilty as to count 15. If you find the defendant guilty of count 15, you must answer the following question, yes or no. Did the defendant commit the crime of first degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 16, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 16. If you are not so satisfied, you must find the defendant not guilty as to count 16.
And I
If you find the
appreciate you for
defendant
that.
guilty of count 16, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 17, you should find the defendant guilty of first degree recklessly
And what are the
endangering
odds that
safety
you're the
as charged
first
in
one
count
here
17.
and you're just a
If you are
40-minute
not
drive
so
away?
satisfied, you must find the defendant not guilty as to count 17. If you find the defendant guilty of count 17, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 18, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 18. If you are not so satisfied, you must find the defendant not guilty as to count 18.
Every
if you
now
find the
and
defendant
then,
guilty of count 18, you must answer the
I run
following
into a
question,
reminder
yes
of just
or
how
no.
small
Did
the
the
world
defendant
is.
commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 19, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 19. If you are not so satisfied, you must find the defendant not guilty
Hang on.
as to count 19.
I thought it
If
was
you
just
find the
6,000
defendant
years
guilty of count
old.
19, you must answer the following question, yes or no. Did the
I say
defendant
as a
commit the crime of
sarcastic
first
jerk,
degree
of course.
recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering
Well,
safety have been
I
proved
definitely
as to count
appreciate you
20,
sticking
you
around
should
through
find the
my
defendant guilty of first degree
lazy
recklessly endangering
period,
safety as charged
otherwise
in
known
count
as
20.
hiatus.
If you are not so satisfied, you must find the
Like I
defendant
said,
not
I'm going to
guilty
do my best
as
to
to
be
count 20.
more regular.
If you find the defendant guilty of count 20, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 21, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 21. If you are not so satisfied, you must find the defendant not guilty as to count 21. If you find the defendant guilty of count 21, you must answer the following question, yes or no. Did the defendant commit the crime of first degree reckless endangering safety while using a dangerous weapon?
What
If
are
you
you
are
doing here
satisfied
then?
beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 22,
But
You
don't
should
go.
find
Don't
the
go.
defendant guilty of first degree recklessly endangering safety as charged in count 22. If you are not so satisfied, you must find the defendant not guilty as to count 22. If you find the defendant guilty of count 22,
And
you
thanks
must
for your
answer
help during the
following
first
question,
half
yes or
hour
no.
of poor
Did the
quality this
defendant
morning.
commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 23, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 23. If you are not so satisfied, you must find the defendant not guilty as to count 23. If you find the defendant guilty of count 23, you must answer the following question, yes or no. Did the defendant
See,
commit the
that
crime of first
was
degree
smart of me.
recklessly
I'm
endangering safety while using a dangerous
blackmailing you
weapon?
into staying.
If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 24, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 24. If you are not so satisfied, you must find the defendant not guilty as to count 24. If you find the defendant guilty of count 24, you must answer the following question, yes or no. Did the defendant commit the crime of first degree
But is
recklessly
it
endangering safety while
coercion?
using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 25, you should find the defendant
That's a good
guilty of
point.
first degree recklessly endangering safety as charged in count 25. If you are not so satisfied, you must find the defendant not guilty as to count 25. If
Like
you
I
find
said,
the defendant guilty of count
this
25,
started way
you must
too
answer
early
the
for me this
following
morning.
question, yes or no.
So my brain might not be
Did the defendant commit the
working.
crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 26, you should find the defendant guilty of count 26. If you are not so satisfied, you must find the defendant not guilty as to count 26. If you find the defendant guilty of count 26, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 27, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 27. If you are not so satisfied, you must find the defendant not guilty as to count 27. If you find the defendant guilty of count 27, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while
I
using a
don't
dangerous
know.
weapon?
It has
If you
value
are
to me, though,
satisfied beyond a
because
reasonable doubt that
with
all three
the
elements of
pending
first degree
exponential
recklessly
growth,
endangering safety have been proved as to
I
count
will value my
28,
moderators.
you should find the defendant guilty of first degree recklessly endangering safety as charged in count 28. If you are not so satisfied, you must find the defendant not guilty as to count 28. If you find the defendant guilty of count 28, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 29, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 29. If you are not so satisfied, you must find the defendant not guilty as to count 29. If you find the defendant guilty of count 29, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering
I think
safety
after
while
lunch we're
using a
getting more
dangerous
exciting.
weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been
Mr.
proved as to count
Brooks,
30, you should find the
I
defendant
think
guilty
we'll
of first
have a
degree recklessly
opening
endangering
statement
safety as charged in count 30.
that could
If
be
you are
fairly
not so
classified
satisfied, you
as,
must find the defendant not
shall we
guilty as to
say,
count 30.
a poop
If you
show.
find the defendant guilty of count 30, you must answer the following question, yes or no.
But he's
Did the
mad.
defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 31, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 31. If you are not so satisfied, you must find the defendant not guilty as to count 31. If you find the defendant guilty of count 31, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering
I wouldn't
safety
know.
while using a dangerous
You're the
weapon?
one with the farm.
If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 32, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 32. If you are not so satisfied, you must find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty as to count 32. If you find the defendant guilty of count 32, you
It's
must
a
answer the
fecal
following
display.
question, yes or no. Did the defendant commit the crime of first degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 33, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 33. If you are not so satisfied, you must find the defendant not guilty as to count 33. If you find the defendant guilty of count 33, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 34, you should find the defendant guilty of first degree recklessly endangering safety
Since we
as
don't
charged in
have
count 34.
elected judges here
If
in
you are
Utah,
not so satisfied, you must
that's
find the
not gonna
defendant not
happen.
guilty as to count 34. If you find the defendant guilty of count 34, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon?
Even living in England
If you
for
are
a year,
satisfied
I
beyond a
couldn't
reasonable
develop a
doubt that all
posh
three
accent.
elements of first degree recklessly endangering safety have been proved as to count 35, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 35. If you are not so satisfied, you must find the defendant not guilty as to count 35. If you find the defendant guilty of count 35, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly
I need
endangering
to get
safety
over the
have been
lingering
proved as to count
effects of this
36,
plague.
you should find the defendant guilty of first degree
The longer I
recklessly
go, the
endangering
worse
safety as
it
charged in
gets.
count 36. If you are not so satisfied, you must find the defendant not guilty as to count 36. If you find the defendant guilty of count 36, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 37,
The instructions are
find the
definitely
defendant
going to go
guilty
all the
of
way to
first
lunch,
degree recklessly endangering safety
since it's
as charged
noon
in count
now in
37.
Wisconsin.
If you are not so satisfied, you must find the defendant not guilty as to count 37. If you find the defendant guilty of count 37, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? Ladies and gentlemen of the jury, I still have many pages of my jury instructions yet to read to you. However, it's 11:54, and I would like to break, at least for the jurors, to have lunch. I have some legal issues.
Looks like we're a
do
few
need to
minutes
take up with the
behind.
parties, but when you come back, the court will continue where we left off with the jury instructions. The jurors are excused for lunch. At least an hour for them. It might be more, I'm not sure. It depends on when we break.
All right. Let's see if she said depending on when they break. Hopefully they break soon because I'm ready for lunch too. And when I do go for lunch, I'm just going to end this broadcast and
Thank you. Be seated.
start a new stream for the afternoon session.
As I indicated prior to bringing the jury in, because of the process that was utilized for this court to approve of the jury instructions, and Mr. Brooks was provided with opportunities to object and provide input, I would not be taking a break or acknowledging, at least at that point on the record, any objection to those. Nonetheless, he
No
held up his
charge.
objection sign for much of the reading of the preliminary instructions. At 10:37 a.m., I received a note. I don't consent to that name. It is not me. It is not my name. Please let me object to this as it is my right. His objection is noted. I'm not going to take any further argument on that for the reasons I've already stated. At 10:48 a.m., he sent another note. Are you going to acknowledge my objection?
I think
What
I've
law
watched
are you
that.
citing when you cite intent?
I have watched
How
a lot
do I
of the
know
British legal
It's what
shows.
the law actually says. I would once again refer Mr. Brooks to document number 244, the waiver of right to attorney form. This court is under no obligation and in fact cannot give him legal advice and is not required to explain court procedures or the law. He was provided with a couple of different copies of the jury instructions. There was an original set, and then there was the set with the modifications. All of the instruction numbers are left in the jury instructions. There was a discussion on the record
That's good.
yesterday about access to jury instructions, even though this court is under no obligation, and explained that to him during the colloquy regarding the waiver of counsel, that I could not make any assurances about access to legal materials. I note he has his objection sign up. His objection is noted.
Sovereign
But at this
citizens
point,
require
I'm
so
still
much
reading through these objections.
repetition.
I don't plan on having the
and
parties make
redundancy.
any additional comments regarding the jury, the preliminary jury instructions. Again, we had ample opportunity for that discussion prior to the court's approval. Mr. Brooks, I will
He's gonna
once
object to
again
lunch.
advise you that you are welcome back into this courtroom should you wish, if you are able to conform your conduct to the rules of courtesy and decorum that you have been previously been advised about. Once again, direct your attention to SCR Chapter 62, standards of courtesy and decorum for the courts of Wisconsin. Would also
course.
direct you to Illinois versus Allen. That's the case I've been relying upon.
Does it hurt your opinion, though, that
for the
I was so
procedures that
far
have
north that
been
I was almost in
employed.
Scotland?
Mr. Brooks is holding up the objection sign. I don't have anything in writing, which is the procedure that I told him he needed to follow in terms of me addressing
And
any
I'm
objections.
so tempted at some point to
So
just
if he wants to
drive up.
write down what his objection
Coeur
is.
d'Alene's a
and
beautiful,
we'll
beautiful
file
area.
that. We'll also
Drive
indicate
up
the
and
time.
go to
if
the
appropriate,
courthouse
I'll
and
take that up after
try to
the
shake
break, but at
P.
this point, I
Barnes's
will be
hand.
breaking for the noon hour, for the lunch hour. It's 12 noon. Let's be back here at 1 p.m.
And could he also have the opportunity to change into his street clothes if he wants during the lunch break?
Absolutely.
That's
during
good of
lunch
the
break,
prosecutor to bring
I'm
that
told,
up.
will be seen by jail medical staff for the concerns that he's raised. He will be given the opportunity to change into his street clothing, should he choose. Of course, when he comes back, once again, invited back into this courtroom, should he choose.
Yes, and I would just observe for the
I
record
didn't
that
quite
for
make it
about
into
the last
Scotland,
hour while you were
unfortunately,
reading the jury
but
instructions, Mr. Brooks did not appear to be in any physical pain or
I-
medical distress. He's
I
been,
love the north.
moving around freely, shuffling his papers, reading his documents, actually behaving quite appropriately,
I was
standing
in
quietly,
Durham,
oftentimes with
which
his
is
hands
just
folded.
south of Newcastle.
And at times listening to the court, and at times it appears he's working or looking at materials on his table.
All right, thank you. I appreciate that. We are in recess.
Thank you.
And with that, I'm also going to take my lunch break. So, like I said, I'm going to end this stream and then start a whole new afternoon stream. I think that's just going to be the most efficient way to do it. So, hopefully I'll see all of you in the afternoon. So, see you in a little bit.